Hello and welcome back to day 2 of the Federal Bar Association's annual employment law program. To those of you who were here yesterday and to those of you who are new, I am Brenda Feiss, member of the FBA's Board of Directors and chair of our Employment Committee. We have 2 more great programs today, and if you like our programming, and we have lots of good ones in addition to these, I encourage you to consider joining the FBA's Chicago chapter. You can sign up on our website, www.fedbarchicago.org/membership. Some final tech notes before we begin. This program will be recorded and you can watch it within 2 months to get CLE credit. All materials and bios for both sessions, yesterday and today, are available to download from this platform before the program ends. And one very important point, please complete your CLE forms at the end of the program and do take a moment to complete our program evaluations. Your feedback is very important to us. So thank you all for being here, and it is my privilege to turn it over to our next program about changing standards in employment discrimination cases.
Thank you, Brenda. Hi, everybody. I am Diane Smason. I'm the Deputy Director of the Chicago District Office of the EEOC. I'm really thrilled to be here today with 3 very smart and experienced panelists who are going to walk us through some tricky issues. I have Jamie Franklin here. She is an assistant clinical professor of law in the Civil Litigation Clinic at Chicago Kent College of Law. Nieves Bolianos is a founding partner at Fish Potter Bolianos. Margot Wolf O'Donnell is the co-chair and partner of the Labor and Employment Practice at Benish, Friedlander, Copeland, and Aronoff. Welcome to all of you. Thank you for joining us today. So we are going to be discussing changing legal standards in discrimination cases. And we came up with this topic. In part, I suggested it because I have found some of the standards to be very confusing in terms of how they interact with each other, and not to mention the changes that we've seen over the years, and most recently in the Supreme Court Bostock case, which we'll be talking about from only a year and a half ago. And in preparing for this panel and in doing some research for it, I discovered that I'm confused because it is confusing. And I don't think it's just me, and I'm assuming that the rest of you have throughout your practices encountered some confusion. And we are going to provide a little clarification today, but we're going to probably raise a lot more questions than we're able to answer, but give you some food for thought about how these standards have developed over time, how they interplay with each other, and how you can best utilize them in your practice. So next slide, please. We're going to talk about current standards under Title VII, the ADEA, ADA, Title VII Retaliation, and Section 1981. Next slide, please. We'll start with Title VII. Quick overview, just so you know, or as a reminder for those of you who may not, it shall be an unlawful employment practice for an employer to fail or refuse to hire or discharge any individual or otherwise discriminate against them with respect to compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. So because of is the key phrase that courts have been debating now for years and years. What does that mean? Well, before we get there, and we will talk a lot about that, I want to point out that in 1991, the Civil Rights Act was amended, and Congress added this other standard called motivating factor. And motivating factor basically said that You can establish an unlawful employment practice if you can show that your race, color, religion, sex, national origin was a motivating factor for any employment practice, even though other factors also motivated the practice. Sometimes this is referred to as a mixed motive case. This concept originated in the Price Waterhouse v. Hopkins case in 1989 at the Supreme Court, and the adoption of this Civil Rights Act of 1991 was in part a response to that. So Congress established sort of another way to prove discrimination because there was some recognition that it's unlikely that only one factor may play into someone's employment decision. However, Congress decided if that's the case, we're going to limit the relief. So you can't get damages or reinstatement, but you can get declaratory and injunctive relief, and you can get attorney's fees and costs, which, as we know, can actually be quite a lot, and sometimes more than the recovery. So we have these sort of two competing under Title VII because of and motivating factor. Next, we're going to talk about age discrimination in Employment Act. Nieves, go ahead.
So the ADEA contains very similar language to the first section we looked at in Title VII. It should be unlawful for an employer to fail or refuse to hire, discharge any individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's age. And the issue in Gross was that there was a jury instruction given, and it was a mixed motive jury instruction. And the Supreme Court found that that was inappropriate because largely looking at the text of the statute, there was not a factor language included, and that Congress, in its sweeping amendments during 1991, had seemingly specifically opted not to include that in the ADA's language. So the court held that there was a arguably higher standard of proof under the ADEA, and that the word "but" here means by reason of, on account of, or but for. Age has to be the but for reason that caused the adverse action. And so what's interesting there is then, as Diane pointed out, what does but for mean? It means because of. Well, what does because of mean? And so we sort of go on and on there. Is it the hair that broke the camel's back? Is it the thing that tipped the scales? And I think courts and litigants have really struggled with sort of defining that language. Another interesting thing in the ADA, after Gross, the court confirmed that there is not going to be any burden shift to show that something would have happened regardless of the discrimination based on age. And also interesting is at this point, the court's reasoning was narrowly limited to the ADEA. It didn't really call into its analysis any other statute, but spoiler alert, things may change.
Next slide, please.
Under the ADA, you're probably aware that the standard is, a covered individual is a qualified individual with a disability. And really, I'm seeing a lot of these issues arise, and I think there are going to be more and more of these types of claims with COVID and employees having long COVID and issues that might qualify as a disability under the ADA. So I think we're going to possibly see more of these claims, or at least employers need to consider them more. And just top of mind what the standard is, it's does someone have a physical or mental impairment that substantially limits a major life activity? Do they have a record of such impairment? Are they regarded as having such impairment? And the statute itself says, no covered entity, which is 15 or more employees, shall discriminate against a qualified individual on the basis of a disability, and that's quite broad, as I just described, in regard to job application procedures, hiring, advancement, or discharge, compensation, training, other terms and conditions. Oftentimes, sometimes this segues with the FMLA too, with leave issues as well. And in 2008, the language of the ADA was changed to because of a disability instead of on the basis of a disability. And the Supreme Court so far has declined to address ADA standards specifically, but the Seventh Circuit has looked into this. The Serwaka case says that the disability is the but-for reason and arguably the sole reason for the adverse employment action, that's the proof that needs to be shown in order to prove a claim under the ADA. So in some ways, the ADA, we might view a different, distinct standard from Title VII discrimination claims. Next slide. And in the McCann case, interestingly, it said the same sort of type of ruling with the Seventh Circuit. It's very, very recent. They also applied the but-for standard. And quoting from the case itself, it said that the ultimate question in a discriminatory employment termination case under the ADA is whether a reasonable juror could conclude that the plaintiff would have kept his job if he was not disabled. So in this case, they infused this idea of, would the same decision have been made had the person not had a disability? So really what we're seeing is this but-for standard, really thinking in terms of, would the same decision have been made had the person not had a disability in the Seventh Circuit, and also the but-for standard has been applied in the Second, Fourth, Sixth, and Ninth Circuits.
So retaliation, we'll talk a little bit about retaliation now. Retaliation claims often accompany discrimination claims. Sometimes they stand alone. Sometimes they can prevail even if the underlying discrimination claim didn't prevail. So they're a big part, as I'm sure all of you know, a big part of employment discrimination litigation. The Title VII's anti-retaliation provision is a separate provision from the discrimination section, and it says as follows: it shall be unlawful employment practice for an employer to discriminate against any of his employees, and I'm going to use the male pronouns because that's in the statute. I'm sorry about that. Because he has opposed any practice made unlawful by this subchapter, or because he has made a charge, testified, assisted, or participated in any manner of an investigation, proceeding, or hearing, etc. So retaliation claims can arise if a person complains about the discrimination that's happening and then something new happens to that person. The standard, at least pre-Bostock, which we're going to talk about in a minute, for retaliation claims was solidified in the Supreme Court case University of Texas Southwestern versus Nassar. And in Nassar, the Supreme Court did, analyze the whole, did a lot of analysis, but the short answer here is that the Supreme Court applied the but-for standard to retaliation claims as well. So, in a way, that means, as with the standard that Margot was just talking about, that means that theoretically retaliation claims have a higher standard than discrimination claims. But again, we'll talk about whether that standard really is higher. Nassar rejected the motivating factor standard of causation for retaliation claims. And I just wanted to note at the end of my my little section here, the case Serwatka, which I think Margot also just talked about, even though that's not a retaliation case, is very sort of, it's kind of the Seventh Circuit's attempt to describe what a but-for analysis is, or at least the most recent one. And it is not a model of clarity, I have to say. It says as follows: in a but-for analysis, a defendant may have had other motivations for firing the employee. So right there, the Seventh Circuit is saying about the but-for analysis, it doesn't have to be the discriminatory reason or the retaliatory reason may not be the only reason. So right at that point, we're injecting some uncertainty into it. And then it continues, but if the employer would not have fired her if not for the protected category, it is the but-for reason and arguably the sole reason the person was fired. I, again, think that that's not, it's not a clear roadmap for us to figure out what the bottom line is in causation for retaliation claims.
Thank you, Jamie. Good point. And we're going to continue talking about the confusion in the courts as well on these standards. Last statute to talk about is Section 1981. Nieves, if you could explain that.
Sure. Many of you are probably familiar with this statute. It is a statute that also prohibits discrimination in the making and enforcing of contracts. The language at issue in this particular case, Comcast v. National Association of African American Media, was all persons, I'm going to paraphrase because the court did, shall have the same right to make and enforce contracts as is enjoyed by white citizens. And before I go there, I just wanted to sort of follow up on something Jamie just said. When Gross came down, the court said, despite all this language about, but for and because of, and it has to be the reason and the only reason and the main reason, it did say, hence the burden of persuasion necessary to establish employer liability is the same in alleged mixed motive cases as in any other ADEA disparate treatment action. A plaintiff must prove by a preponderance of the evidence, which may be direct or circumstantial, that age was the but-for cause of the challenged employer decision. So even in that case, where we really thought, like, wow, this but-for causation is the thing and it's going to change everything, the courts are still infusing the idea of mixed motives, just not as a jury instruction, not as a standard, but the idea that there could be more than one reason for the adverse employment decision. And Comcast, the court sort of fights heavily, both Nassar and the ADEA, and but it really focuses on the text of the statute and says that, ask yourself what would have happened under the same exact facts, but if the plaintiff had not been African American. And that seems to suggest a but-for causation standard. The court also looked and said, look, when a statute doesn't contain a causation standard within its own text, we should look to tort law, and tort law traditionally requires but-for causation. And so that would make sense here. The court also looked at the criminal portion of the statute, which required but-for causation, and thought that it would be just only consistent and very inconsistent if they were to apply a different standard to the civil part, the portion that provides an implied private right of action. And they also noted that this private right of action, which was judicially inferred, it's not within the statutory text, use language that we often associate with a but-for standard. One of the phrases being, or one of the opinions saying, that when someone is not afforded the same rights because he or she is African American. And so that lends to the idea that there should be a but-for standard in 1981 cases. And then I guess that still leaves us with the question, what does but-for mean? Which is a great segue into our next topic.
Thank you, Nieves. So Bostock arguably changed the landscape, or maybe it didn't. Maybe it just sort of confirmed what we were all thinking. I don't know. Maybe it raised more questions. That's something we're going to talk about. So as a refresher, Bostock combined 3 different cases. It was an analysis under Title VII on sexual orientation and transgender status, and of course found that those are encompassed under Title VII. I'm not going to go through the facts or anything on that. We want to really focus on what the court said about the because of test, because they were looking at that analysis under Title VII, which is the because of analysis. They said the test incorporates the simple and traditional standard of but-for causation. They cited to Nassar and Gross, which we just discussed in the ADEA and retaliation context, but they said very clearly, but-for does not need to be the sole or primary reason. It can be several reasons. And one way they suggested we think about it is it directs us to change one thing at a time and then see if the outcome changes. If it does, then we have a but-for cause. This is a sweeping standard, the court said. Often events have multiple but-for causes. So this is, I think, arguably a different way of thinking about it from what the Supreme Court had said in the Nassar and Gross cases, where the suggestion was it was really one factor, sole cause. This means that a defendant cannot avoid liability just by citing some other factor that contributed to its challenged employment decision. So long as the protected category was just one but-for cause of that decision, that is enough to trigger the law. Next slide, please. Now, what does Bostock say about motivating factor standard? Like, does that still exist? So what they say is they refer to it as a more forgiving standard. Liability can sometimes follow under that standard, even if sex wasn't a but-for cause of the employer's challenge decision. Still, because nothing in our analysis depends on the motivating factors test, we're going to focus on what they call the traditional but-for causation standard that continues to afford a viable, if no longer exclusive, path to relief under Title VII. So the court here seems to be saying that motivating factor and but-for are two different standards that can be used to prove discrimination. The more forgiving standard is motivating factor. But what's the difference? Is there a difference? And this is something that I've been thinking a lot about. Don't both standards actually suggest that there are multiple reasons behind the employment decision? Jamie, what do you think of that?
Well, I think that you're absolutely right that Bostock, it does not necessarily clarify for us the difference between but-for and motivating factor. If I could step back for just a second and kind of create kind of the scenario in which we care about these things. So in employment discrimination cases, we often find that the employer files a motion for summary judgment and the employee defends against that motion. That's where these standards matter. That's where they're applied. If the case goes to trial, none of this really matters because the jury will decide what they think. But so keep in mind that all of this is really geared toward a motion for summary judgment. And in that sort of situation, the plaintiff is putting forth all sorts of facts to try to convince the judge that discrimination occurred, and defendant is doing the same on its side. So the way I look at it, one of the ways I look at it is I'm troubled by the fact that we're asking judges to sort of go beyond what I consider to be the standard of summary judgment, which is construing all facts and inferences in favor of the non-moving party, not making credibility determinations, etc. So what we're doing, I think, is asking judges to look at the facts, to dissect them, to figure out which fact or which issue was either a but-for or a motivating factor, depending on which part of the statute you're going under. And it's not the judge's fault. They're being asked to do things that really, in my view, are, for a jury. But anyway, that's my little screed. And I don't know what the real difference is between the two standards, because they both, under Bostock and under other case law, can involve more than one reason for the actions. So I guess the bottom line for me is the burden is always on the judges to figure this out, and it's a difficult burden and possibly an unfair burden.
Thank you, Jamie. Let's go on to the next slide, and we will be hearing from the other panelists as well. So what is the effect of Bostock on the Seventh Circuit and other case law? Well, we're not sure. That has yet to be written, but Jamie did a little research, and there wasn't a lot in the Seventh Circuit yet citing Bostock for really what the standard means. But she did come across this one case, Aravello-Carrasco, where the Seventh Circuit reiterated Bostock's holding, saying if discrimination were merely one reason for his termination, Aravello would still prevail under Title VII's motivating factor standard. And then they cite Bostock and say protected characteristic is one but for cause is enough to trigger Title VII. Again, to me, that seems sort of continuing to muddy this, well, what is the difference between but for and motivating factor? So it raises the question, does this mean this is how courts should be applying but for causation in all of these kinds of cases under these statutes we've discussed? Age, disability, Title VII retaliation, and Section 1981 cases? Yevis, what do you think of that?
I think that the court has sort of been telling us, and maybe we haven't been understanding, but for was never intended to be a sole causation standard. But for doesn't mean sole causation, and under the same reasoning that if Congress had intended for these other statutes to have a motivating factor or a mixed motive instruction in their jury instructions, they could have done so when they amended these statutes, particularly in 1991. Seems to be the watershed year, and they didn't. So I think that and as I pointed out in the ADEA case, the seminal Gross case where it says but for is the causation standard, the court still talks about mixed motive cases and that those cases still exist. It's just that you prove them the same way you would any other but for case, like we would a tort case, like we would Section 1981. It doesn't mean there aren't other factors. It doesn't mean there aren't other reasons. It's just as you take things away, would things have resulted the same way they did if age, race, or whatever other protected characteristic was not in play? So, I think that's the way we have to look at these cases. It's just, when we are faced with, sort of this back and forth of, well, we have another reason, and now I have to disprove that that was the reason. I think that's what really has added an additional burden on us, and doesn't exist in almost any other case. And the court is kind of saying that, like, you should be trying these cases the same way you would any other case. This is derived from tort law. This is derived from, traditional statutory language. Get your evidence. Go bring your case.
Thanks, Nieves. And we're going to talk more about that. What does it really mean for proving a case in just a moment? I wanted to ask Margot, though, if she has any ideas particularly from the defense perspective, what other takeaways maybe you've gotten from Bostock that you share with your clients?
Well, I think it's important from my perspective. I mean, this isn't just about summary judgment. This is about counseling and determining how to make decisions regarding employees, before those decisions are made, investigating claims as well and evaluating them, deciding whether claims are worth litigating or they settlement makes sense in certain instances. I mean, I'm not sure that Bostock gives clarity, but it does cause employers to think carefully about what is the reason for the decision. Also, if you were to litigate, what is the evidence? What will the decision maker testify? What do the documents look like as well? And also, I mean, think carefully before you're making decisions with individuals in protected classes as well, you know, what are the business reasons for these types of determinations? I've also found, you know, the effect of Bostock and also the pressure on the economy as well. I mean, it's been difficult for employers in certain situations to make hard decisions about, you know, moving forward, you know, adverse employment actions as well need to be considered carefully. So I would say that, like always, employers that I work with, we consider, you know, all the facts carefully before a decision is made.
And Margot, to follow up on that, I'm just wondering, you know, some people in the plaintiff's bar, I think, thought of Bostock as being a real win. And
Right.
Obviously for coverage purposes, definitely for coverage, you know, for transgender and sexual orientation. But what
Right.
about for its statement of there can be multiple causes, and if there's one that you can prove to be but for that is discriminatory, you're in trouble. Like, do you think the defense bar viewed that as like, oh, wow, we need to be a little more careful that this is harder for us now to justify our decisions?
I mean, I haven't felt that necessarily. I mean, I think that should always be considered when making employment decisions as to, you know, are these reasons based on any sort of protected characteristic, or, you know, when you're making that decision. I think some in the defense bar probably agree with that there should be, you know, more consideration when you're making decisions as to employees who might, you know, be able to make a claim under Title VII or the ADA or section, you know, in Section 1981 or the ADEA. I mean, I think when there's a big employment decision to be made, especially like a group termination, I think that maybe because those decisions are being made so much more frequently now, I think they are maybe considering it more carefully as well, probably because of Bostock and also because of the effects of COVID.
Sure. Thank you. Okay, let's go on to the next slide. So what does all of this mean for proving a case? And Jamie and Nieves alluded to this in terms of what does this, you know, what do we do with these standards now? And particularly for discrimination law, what does it mean for McDonnell Douglas? You know, that is the long-standing burden shifting method of proof that we use on summary judgment that everybody sort of falls back on and relies on. And that's really a separate concept. You know, the standards are, the but-for standard is different than how are you actually going to prove, what's the framework you're going to use to prove your case? And McDonnell Douglas has long been used. Is it still needed? Is the McDonnell Douglas framework consistent or inconsistent with the but-for analysis? And now, are there two different methods available to prove discrimination based on the type of evidence? I'm going to ask Jamie to address what this may mean for McDonnell Douglas and what you think of it now.
Okay, well, from my perspective as a plaintiff's attorney, I would not be sorry to see McDonnell Douglas go by the wayside. McDonnell, and just to reiterate what it is to refresh people's memory, McDonnell Douglas requires 4 things to create a prima facie case for a plaintiff. The plaintiff has to be in a protected group, has to be meeting the employer's expectations. There's an adverse employment action that happens, and then the employee has to show that similarly situated people without their characteristic were not treated the same. After that happens, the employer then asserts a legitimate non-discriminatory reason. After that, the employee needs to show that reason was pretextual. And then, of course, there's the final step, which is still causation. Even with McDonnell Douglas, you have to show causation. So my view is we could jettison McDonnell Douglas altogether and just go right to the but-for causation. I do think that in my view, and we're going to talk a little bit more about another way of proving cases in the Seventh Circuit in a second, but I won't jump ahead to that. But my last point is that I've seen McDonnell Douglas used as sort of a map for a way to attack a plaintiff's case. And I want to kind of reiterate a point that I think maybe I didn't make earlier, which is all this technical discussion of burdens of proof and how things work and burden shifting methods in a way kind of obscures the point that I think discrimination really exists. It really happens in the workplace. It's something that goes on every single day. It may be less overt than in the past, so it may not fit McDonnell Douglas anymore. Discrimination in the workplace doesn't necessarily take the form of a slur or a grope. It can be very subtle. It can be someone is left out of meetings and ignored and not groomed for promotions. That's the way it looks now. So how do you fit that into McDonnell Douglas? That's a question that I think plaintiffs' lawyers struggle with.
And let's go on to the next slide to talk about the standard in the Seventh Circuit so that we can have a more robust discussion then about what the different options are, and we'll hear from the other panelists as well. So what does this mean in the Seventh Circuit? Okay, so there have been some changing standards in the Seventh Circuit. For a while, the court had been referring to a convincing mosaic, which I liked because I thought it was very, I could visualize it, and I think it helped think about like sort of the different pieces you put together almost in a puzzle to see what really happened. But in 2016, the court, Seventh Circuit now came out with Ortiz, where they replaced that with totality of the circumstances. And really, they said, we never intended the mosaic, the concept of that to be a standard anyway. But to the extent courts were using it as a standard, and they were, we want to replace it with totality of the circumstances. And the court said, what this means is we're not going to separate the evidence into two buckets of direct and circumstantial evidence, which is what courts had been doing for direct and indirect methods of proof. Instead, the ultimate question is whether the prohibited factor motivated the employment decision. So now they're using the language of motivation. You got to look at the evidence as a whole. They say mosaic was never meant to be, a standard. And what I want to talk about now is sort of what does this mean for us who practice in the Seventh Circuit in terms of what are the standards? How does that play into McDonnell Douglas? And just as an aside, we wondered, what are other circuits doing with respect to this concept? Because it's a very practical concept, right? Let's look at the totality. Let's look at everything that's going on. And Jamie did some research and found that the 3rd, 6th, 9th, and 11th circuits are at least open to analyzing cases under this kind of broader concept. And all of their cases in those circuits, all of which cite Ortiz. So what does this mean in theory and in practice? Is this a helpful way to analyze a claim? And then I'd like to go back to tie it into McDonnell Douglas. How does this tie into that framework? By the way, in Ortiz, the Seventh Circuit says it has nothing to do with it, that McDonnell Douglas has nothing to do with it, and that it's consistent with a burden shifting framework, that the totality of the circumstance standard, they say, is consistent. Is it? I'm not sure about that. Nieves, why don't you speak to any of that you'd like to, and then we'll hear from the defense perspective from Margot.
I think, again, that these were helpful. This was helpful guidance from the courts in sort of getting us to be trial ready. It allows plaintiffs to bring forward evidence of their claim and without having to necessarily disprove a defense in order to get before a jury, which I think has become the problem with the burden shifting and the McDonnell Douglas standards. It's almost as though you have to jump through an additional hoop that you wouldn't really have in any other kind of case just in order to get before a jury. And so I think these have been helpful cases because they talk about all the different kinds of evidence that will help a plaintiff show what they're saying is probably true, more true than not. And if that's the case, then it really should be the jury that's making the call, not the judge, based on briefs and depositions and documents. So that's sort of how I saw these cases, and I thought that the Seventh Circuit was sort of trying to go that route even before Bostock came down and sort of, I think, clarified that, you know, but for is not this strict, you know, causation standard that some courts apply. You know, it's certainly never sole causation, and it should allow for plaintiffs to be able to bring, you know, all different kinds of evidence to the table to prove their case, while not having to disprove the evidence that the defendants are going to bring, in order to say, look, that wasn't the real reason. We had all these other legitimate non-discriminatory reasons for the adverse action.
Thank you. Margot, I'd like to hear from you, your perspective on this. And in terms of when you are recommending filing for summary judgment, because as Jamie pointed out, this is where this really shows up a lot. You know, that's sort of the first gatekeeper. Can we get past summary judgment or not? And I'd like to know, when you're advising clients, what do you advise them in terms of the analysis? Do you look at McDonnell Douglas? Do you look at totality of the circumstances? Do you do both?
I believe you do both, and I think that's what defense counsel is, that's generally what defense counsel, what they're doing in summary judgment motions, because, I mean, McDonnell Douglas is still out there, and it's important to cover all arguments when you're filing for summary judgment. From our perspective, it's a way to organize the evidence as well, because sometimes, you know, you're coming into summary judgment, you have to think of a way to present the evidence in a summary judgment motion in an organized fashion, make it easy for the judge to write an opinion. I mean, that's my goal. If I'm getting all the way to summary judgment, I believe in my case, and I believe we're entitled to summary judgment. So I'm going to use every angle possible under the law in order to prevail at that point. So.
And Jamie, what do you think of that? I know from our discussions you have some strong feelings about that, whether or not defendants tend to now choose one or the other option, or do both.
Well, what we've seen in our clinic and in my practice is that defendants do both. So now, after Ortiz, there's sort of two arguments that are in every summary judgment motion. There's plaintiff doesn't prevail under McDonnell Douglas, and then also plaintiff doesn't prevail under Ortiz. So there's really just two steps now instead of one, which may increase the workload for plaintiffs. But in reality, what is totality of the circumstances, or totality of the evidence? What does that really even mean? Does that mean just reiterating all of your facts in your 15-page brief, which would not be possible? I'm not sure that we practitioners really know what totality of the evidence should look like. You know, is it a summary of your best evidence? Is it in and of itself, does it need to have the elements of a McDonnell Douglas burden shifting? You know, does it need to address, as Nieves was saying, under McDonnell Douglas, you sort of have to anticipate the employer's defenses and disprove those before you could even get to trial. Does totality of the evidence still make you do that? I think it's unclear. I'm pretty sure the Seventh Circuit's going to give us more guidance on that at some point, and that'll be interesting to see.
Does it make you, when you're evaluating cases, which ones to take on? I mean, does this changing standard impact that? I guess that's a question for Nieves. Yeah. Because, I mean, I'm evaluating cases as, representing employers, but you do that as well, I assume.
Mm-hmm.
Yeah, that's a great question. What do you think, Nieves?
Yeah, we accept that there can be many reasons, just as we can have a discrimination case that's a hybrid, right? Because you're a Black woman, not just because you're a Black person. because you're an old and disabled person, not just because, you know, you're over 40. So sure, we absolutely assess, you know, what were the other things going on in the workplace? What led up to this? You know, what's the personnel file look like? What were the reviews like? You know, of course, we're looking at every single element that could come into play when it comes to these claims. Timing, you know, how long have you been there? Were there any recent changes? All of that. And I think, you know, that fits sort of the totality of the circumstances for sure. But, you know, also having to prepare for the fact that we may have to address, you know, something that the employer says is a legitimate non-discriminatory reason, and how are we going to do that? Can we do that? Is a judge going to agree with us that there's a, that a jury should decide it? So we absolutely assess those sorts of things.
Okay, I feel like we could keep talking about this all day. And in fact, this panel, we've spent many hours talking about it, but let's try to put this into practice a little bit and see what we think these standards might mean in a hypothetical case. Next slide, please. So Susan and Tom are both assistants to an executive at a company. Their boss recently retired and Mark was hired as the new executive. Susan is a devout Christian. She attends church regularly. She talks about her strong beliefs. She frequently signs emails, "Have a blessed day." She tells people, "God bless you," at the end of a conversation. She wears a pin with a cross on it on her coat and purse. She has other visible religious themed items in her cubicle that people can see. Tom, on the other hand, is mentioned. He's Christian as well, but he doesn't discuss his religion at work. He doesn't attend church regularly. He appears to be pretty non-observant. Over a 3-month period, Susan made a few mistakes in her work. So for example, she sent an email with important information to the wrong client. She ordered incorrect office supplies, and she misfiled a contract such that Mark could not find it for several hours one day when she was out. Over the same 3-month period, Tom also made a few mistakes at work, but they were all internal errors, and unlike Susan's, it didn't affect a client or Mark personally. Next slide, please. Mark talked to Susan after the first 2 mistakes, asked her to be more careful. She apologized, thanked him, and said, "I hope God continues to bless you and your family. I'm going to pray for you. Please let me know if you'd ever like to go to my church. They're very welcoming to everyone." He responded by saying, "You know, I'd appreciate it if you don't discuss or share your religious views with others at the office. I don't think it's appropriate." Similarly, Mark talked to Tom after his first 2 mistakes, and he asked him to be more careful, and Mark agreed he would certainly try to be. After Susan and Mark spoke, Susan emailed HR asking whether what Mark told her was okay, meaning, you know, you shouldn't be discussing your religious views at work. Is that okay, she asked. And she questioned if she had a right to express her views about religion at work. After Susan's 3rd mistake, Mark fired her in consultation with HR. After Tom's 3rd mistake, however, Mark gave him a written warning. Now, Mark is a committed atheist. He doesn't practice any religion, and he strongly dislikes when people talk about their religion or appear to proselytize at work. The question is, did Mark engage in discrimination when he fired Susan? Jamie, what do you think of that?
Yeah, it's an interesting hypothetical. So thank you for providing that. It's similar to a lot of cases we see as plaintiff's attorneys. You have your potential client has had something that bad happen, and there's another person who is in the same situation, the same type of job, same supervisor, and is treated differently, and that person is not in the protected group. So Susan could have a claim under Title VII for religious discrimination. She also might have a claim of retaliation because she asked HR whether this was appropriate, and then she was fired after that. So that could raise a retaliation claim as well. You know, I don't know if her claim, I don't know how strong her claim would be. because, you know, the employer is going to say, well, her mistakes were a lot worse than the mistakes that the similarly situated person made. So that's our legitimate non-discriminatory reason for firing her.
Nieves, what do you think, and how, if you were taking this case, how would you try to prove it? Would you try to prove it using McDonnell Douglas, totality of the circumstances, both? How would you try to show but for? Give us some insight into how you would analyze that. If you had Susan come to you and say, will you take my case? I think I've been discriminated against, maybe based on religion, maybe based on gender, maybe I was retaliated against even after I complained.
Can't give you all my secret moves, but
give us a few.
So no. I think, you know, like I said, totality of circumstances is always, I think, a helpful way to look at it. I know we're not supposed to use the mosaic, but in my mind, it kind of works. Like, what's the picture? What are all how do all these pieces fit? What's the timeline? You know, when did all this come up? I agree with Jamie. Those are the same claims I would probably flag potential issues. And I think, you know, for the retaliation, I would say, you know, we do have the potential for a mixed motive. So, you know, at the end of the day, there might not be the same kind of damages available, but it does look like she was treated differently. And so I'd really want to dig into, you know, what were they being disciplined for? What were the mistakes that were made? Have other people made these mistakes? You know, I'm going to have to go to summary judgment. I'm just assuming that. So I'm going to have to, you know, figure out who else is making these mistakes, who else has a similar position, and, you know, what usually happens. What's the practice there when these kinds of mistakes are made? Has she ever made mistakes like this before? Was it not a big deal before, and only now it's starting to be something that, you know, anyone cares about? I'd also want to know whether, you know, other people in the workplace are voicing opinions about things that could, you know, potentially be controversial, and not suffering an adverse action. And, you know, I'd want to, you know, it seems like the direct comparator is Mark. So we'd want to know about Mark, and, you know, what's his work history? How long's he been there? How's he been treated in other circumstances? Is he the brother-in-law vice president? I don't know. So, you know,
oh, you mean Tom, right? I think
she means Tom.
Yeah. You mean Tom is the comparator. Yeah. Mark would be the decision maker. Sure. Okay, just to clarify.
Yes.
And I didn't mean to cut you off. Anything
no,
else?
I think the kinds of things I'd want to look at when I was putting together the case.
So Margot, how do you defend this? You have a client who comes to you and says, there's this lawsuit against us. What do you say?
Well, I think I agree with Nieves. I would ask many of the same questions of my client before we proceed. How long has Susan been employed with the company? You know, what were her performance reviews? Hopefully there were performance reviews like before this. You know, was there a market change after this incident? And how has Tom been treated vis-a-vis Susan? I certainly would try to make distinctions, you know, and this was truly a legitimate business. There was really a legitimate business interest here, that there really was a very strong reason for her termination versus just disciplining Tom, because that type of mistake is somehow distinct from his. I would look and see if there's any sort of company policy that would, you know, support that assertion as well. So I think I would hone in on Susan's performance and performance standards for other employees as well.
Okay, thank you, all of you so much. This is tough, right? But I think it is representative of the cases we see, that there's often a lot going on. And was it religion? Was it possibly gender? Is there retaliation going on? And I think I appreciate that the courts more and more are recognizing that these decisions are not made in a vacuum, and that we are all human beings and we all take into consideration a lot of factors in how we interact with people, and the decisions that businesses have to make are considering human beings and all that comes with them. I think along those lines, I want to pose a question that one of our audience members posed that I think is a great question, and it is something I have long been wondering. Does alleging two different types of discrimination, for example, age and race, undermine the plaintiff's ability to prove that one of those prohibited factors was the sole reason, or the but-for reason, if we're using that standard now, which Bostock tells us we should? Jamie, what do you think of that?
That is a really good question. That comes up a lot when you have claims that are both under Title VII and under the ADA or the ADEA, or even other statutes. I think each claim has to be evaluated individually. And if each claim is evaluated individually using the standard that's appropriate to that claim, I don't think there should be any conflict. It's a confusing situation. A lot of times when you have that happen, defendants will argue that, well, you can't possibly have these two claims because they're mutually exclusive. I don't see that they are. I think, as I said, they should be evaluated individually.
And this is similar to another great question we got that are related, actually, which is, how does this impact the theory of intersectionality, where a plaintiff who's a member of two protected classes, like an African-American woman, she may claim gender discrimination and race discrimination. How does her prove, how do these standards, the realm of these standards, affect how you go about proving that? Nieves, what would you say to that?
I think we see that a lot, that there are, sort of a combination of things. It's like I said earlier, it's not because you're a Black person, it's because you're a Black woman that you've been treated this way. And so I think those are absolutely, the claims are good claims, and you use the same sort of evidence and standards that we've been talking about. If this person wasn't a woman who is Black, would the same thing have happened? Despite all of the other things that may have happened, whether she was not a great typist, whether she came late to work, whether there may have been, a number of other reasons. Was this a reason? And if it was, then you move forward, in my view. So I think, I don't think that they cancel each other out in any way. And in fact, I think that that's one of our jobs, is to create what is the actual protected class. We know that all of these things are protected. Okay, well, what is this one for this particular case? What happened here? And then pulling the evidence to show that that actually was the reason for the adverse action.
Margot, I'm going to, before we wind up, I want to ask you a question, pose that question to you. As a defense attorney, you get a lawsuit where two things are being claimed, right? Race and gender, let's say. Do you think, oh, good, that's actually helpful because one claim kind of takes away from the other, and how does the but-for analysis play into that? Does it make it harder or easier to defend against a claim like that?
Well, I suppose during discovery, you have to think about, multiple issues. So I don't think when I see those types of claims, it doesn't necessarily make me happier, but I suppose under these evolving standards, maybe it might be more difficult for the plaintiff to prove their case because they have more work to do too, I suppose. Maybe in the end, though, discovery will flesh out as to which claim is stronger than the other, and that could happen as well, so.
Or it could be both. And that's sort of what I think a lot of people are saying these days, is that you take us as a package, right? I am a Black, I am an older man, or whatever the case may be. And it is really hard possibly to kind of separate those things out so that we've yet to see how the but-for analysis that now really seems to be taking over this area of law, how that's going to affect these kinds of things. Does that help or hurt if you have more reasons, which is more and more common, right?
Yeah, and it seems like courts sometimes look, decide one claim might be stronger than the other. That's what some of these cases have shown.
True, and that's hard. I think that's a hard thing for courts to do, but that's, yeah, and we need to take advantage of that. Obviously, to put forth our strengths as plaintiffs and as defense to rebut that as much as possible, each possibility. Okay, I am going to sign off. I want to thank the panelists so very much. I thought this was a really interesting and very mind-provoking discussion, and I hope it was for all the rest of you as well. And I'm going to pass this off to Brenda Feist, who will be introducing and moderating the next panel, which will involve several of our judges. And this is always a real highlight of our labor and employment program to hear from the judges. So with no further ado, thank you all very much for joining us, and thank you for the great questions we got as well. Bye-bye.
Welcome, everybody, to the final session of our program, which is our judges panel. Really wish we could be in person, because this is always such a wonderful section of the program to have a chance to mingle with our judges, but we're delighted to have them with us today. As a reminder, we will be soliciting your questions, so feel free to submit them online throughout the program so that we can have them by the end, and we will provide you with the CLE code toward the end of the session. It is my pleasure to introduce our four panelists this morning. Judge Jorge Alonso has been a district court judge on the Northern District of Illinois since 2014. Before that, Judge Alonso served as an associate judge in the Circuit Court of Cook County, where he presided over felony cases in the criminal division. Before taking the bench, Judge Alonso worked as an assistant public defender in the Cook County Public Defender's Office for over a decade. Judge Mary Rowland has been a district court judge since 2019. And before being confirmed as a district court judge, Judge Rowland served as a magistrate judge for the Northern District of Illinois for 7 years. Before that, Judge Rowland spent a decade practicing criminal law in the Chicago Federal Defender's Office, and another decade after that in private practice, specializing in civil rights law. Judge Frank Valderrama, the newest member of our federal bench, has been a district court judge since September 2020. Before joining the federal bench, Judge Valderrama was an associate judge for the Circuit Court of Cook County. And in addition to serving on both the state and federal bench, Judge Valderrama has also been a trial lawyer and an adjunct professor teaching pretrial civil litigation. And last but certainly not least, Judge Jeffrey Cummings has been a magistrate judge in the Northern District of Illinois since February of 2019. Before taking the bench, Judge Cummings spent nearly 30 years in private practice at the law firm Minor, Barnhill, and Galland, which I believe President Obama is an alum as well, where Judge Cummings specialized in employment discrimination cases. Judge Cummings also served as an administrative hearing officer for the City of Chicago's Commission on Human Relations. These judges do so many things in our community. I urge you to read more about their backgrounds in your bios. So judges, if I can, let me kick it off with one of the more obvious questions in this era of COVID. How has remote work affected your case management? Are there advantages you're finding? What are the disadvantages? And are there any changes that you'd actually like to continue once courtrooms fully open again? Anyone feel free to jump in.
So we've gone, to paper. So all of our status reports now are on paper. I personally miss seeing lawyers. I know that lawyers are happy, I think, for the most part, not having to spend a half an hour in the security line downstairs to stand up at a 5-minute conference, and I appreciate that and appreciate saving people's time and money. I do think we've lost something in terms of the chatting that happens in the hallway between council and the calling on the phone the night before to prepare for the status conference. I mean, that's when a lot of stuff gets done in cases, frankly. But I don't know whether judges, when we reopen completely, will get back to every status happening in court. I doubt that. Although the Northern District of Illinois has always sort of prided itself on having a lot of in court time and face-to-face with the judges, or if we'll continue doing so much on paper. But I personally miss seeing people, but I'm a social person.
Excuse me, I would say, good afternoon, everyone. I would say from the standpoint of settlement conferences, we've gone pretty much completely to a remote video settlement conference format. When we first started that, I was really wondering whether it would work out at all, and I was a little skeptical about it, but I think actually it's proven to be quite an asset, and even when things get back to normal, I'll probably still continue to do a lot of the conferences by a remote video means. It gives more flexibility for the parties and their counsel, and it enables you to just have more scheduling flexibility in terms of time, and if you need to go longer, it's easier to do that when people are in the comfort of their home office or maybe their work office. It just seems to have proven to be a real asset in terms of helping us settle the cases. So actually, I kind of like that.
Judge Valderrama, Judge Alonso, do you like it? Do you not like it? What would you keep? What would you get rid of? Judge Valderrama, I think you need to turn on your camera. I mean, your audio.
Brenda, can you hear me?
I can.
All right, I guess I'll go next. I think that like everybody else, the situation with COVID threw us for a loop. I think ultimately we are better because we learn new tricks, right? We can now do this. So we will all have to decide what to do going forward. I suspect federal judges, being who they are, that we'll have 30 different approaches here in the building after things calm down. But I myself, I can't imagine going back to in-person status hearings. What Judge Rowland says is true about what we're missing. And of course, we do miss seeing everybody in person. But I find that in a strange way that these paper reports get us where we need to get more directly than the old status hearing. I think that, for instance, in the old status hearing, I would, in order to show off that I was ready, I would say something about the case. And whatever I said would just get one side or the other off going in some direction, which wasn't really to talk about. So now with these reports, the parties tell me what they need. Many times they agree. If they don't, I'll resolve what needs to be resolved. But I find it productive in that way. So it's not just an alternative, something that we have to do, but I find that it has certain advantages from that standpoint. And I also think, in a sense, we're tricking the attorneys to conferring in order to create something together, a joint status report. And in that way, there's sort of a spirit, I think, that may be beneficial in terms of trying to settle the case and resolve issues, because again, they have to come together, as silly as it sounds, to create this document that is going to be called a joint something. So I think there are definitely benefits that have come from it. There were challenges also. I think the biggest challenge for me personally was that when the notice requirements went away, the danger that a case would fall through the cracks became much more real. And so, speaking for myself, it really created a situation in a day-to-day context where I was doing some of the things that the attorneys would do. I was making sure that there wasn't some motion floating out there, and there were. So you took ownership of your caseload in a way even more so than before COVID, because so much that was attorney driven before COVID, mostly because of the notice requirements. Now, some of those checks went away.
I echo all of the comments of my colleagues regarding what they've seen as far as the effects of COVID on case management. And I would just add a couple of points. Certainly, from my perspective, the scheduling of trials has become a very difficult concept because of the necessity of social distancing and adhering to the COVID protocols as articulated by the chief judge through the CDC's guidelines. So that has been a real issue because judges just don't have the ability to schedule a case for trial in their courtroom whenever he or she is ready to set it for trial. So that's a real challenge and something that certainly for me, it's taken some getting used to navigate that development. I agree also that some of the changes though are for the better. And like Judge Alonso and Judge Rowland have already said, some of those changes probably will not go away. The status calls telephonically or remotely, I think are beneficial, save time, and are more efficient in many ways. And I would expect that to continue going forward once we finally get out of this COVID nightmare. And I think that the last thing I would probably add is on the technology side is that be sure that attorneys know how to use and are familiar with the court's WebEx systems, and be sure that they're familiar with the court's technology so that you don't have issues that they're dropping off, whether it be by remote by phone or even by video, but that they know what to do and how to do it. So it makes it go relatively seamless.
And if I would add a comment I heard Judge Pallmeyer make at our annual FBA luncheon, and she commented on something that really resonated with me as a practitioner, which is one of the real unfortunate downsides of the lack of remote hearings is that young lawyers no longer have the chance to sit in a courtroom and just watch the motion call. Just watch how other lawyers handle themselves in front of the judge. Just watch how the judge handles lawyers. I learned so much as a young lawyer watching Judge Shader deal with litigants and lawyers, and so we're really missing that. So I certainly understand why it's more convenient for the court and the litigants, but I think unfortunately something has been lost. Well, while we're on the topic of COVID, and we're certainly not going to belabor that, we had a whole session on it, but it is inevitable. In the last 21 months of this world we're living in, the courts have been bombarded with COVID-related lawsuits, and more in the employment arena than almost any other. In the last 5 weeks alone, or about 5-6 weeks alone, I found 6 decisions by 6 different judges in this district who have faced motions from employees either to enjoin vaccination mandates or mask mandates. I thought it was interesting that every single one of those judges denied the injunctions allowing the mandates to go forward. And I don't believe any of you were authors of those decisions, but I'm wondering if there is any consensus forming within the Northern District of Illinois among the judges on these vaccine mandate cases. You know, are you having internal discussions? And to the extent any of you have dealt with any aspect of COVID-related cases, if you could comment on that. Judge Alonso.
As you pointed out, none of us, the 4 of us, have had to deal with the mandate issues. I think that all of us probably have dealt with the insurance claims, and I think uniformly those cases have been dismissed, I think at the motion to dismiss stage. But like you pointed out, there have been plenty of our colleagues that have dealt with cases. Last week, Judge Kennelly had a Metra case versus unions. That was a vax mandate case, and all of these cases Not sure if there's a consensus, but there's definitely a trend in every one of these cases. I counted about 10 different cases over the last 22 months. Efforts to enjoin have been denied. TROs, preliminary injunctions have all been denied. The same outcome at the Seventh Circuit level. 4 cases that I found. 3 of those cases started here in the Northern District, but Judge Kennelly's was a vax mandate for federal executive agencies and contractors. He denied the TRO a month before that in December. Judge Coleman in Cisneros versus Chicago, that was a vax mandate case also. This one involving Chicago employees. Again, the TRO was denied there. In November, Jane Doe versus North Shore University Health Systems, that was Judge Ness. This was dealing with North Shore's policy. This was a group of hospital workers who sued, claiming religious exemption. Many of the cases, especially the Seventh Circuit cases, have dealt with free exercise, free speech. But in that case, Judge Ness denied the request for preliminary injunction, finding no irreparable harm. Judge Lee in Trugstad, also in November of last year, denied a case. This was certain employees of the fire department, water department, and transportation department here in the city of Chicago, challenging the city's vaccination policy. The TRO was denied. Judge Shaw, 2 days earlier in November, also dealt with a pro se case, Makowiczi, M-A-H-W-I-K-I-Z-I. This was a pro se rideshare driver, and the TRO was denied. His claim was that wearing the masks violated his free exercise and free speech rights. Judge Johnson out in the Western Division in Strait versus Pritzker denied motions brought by a pro se student out at Rockford Valley College. So he was challenging the requirement for COVID testing. That was brought on an unreasonable search, Fourth Amendment basis. He found that there was a search, but it was reasonable. October of 2020, Judge Kennelly, again, this was a pro se case, Williams versus Trump. This was a case that was grounded in part on an effort to gain the nomination of a party and also free religious exercise grounds. That motion was denied as well. That challenged stay at home as it implicated this candidate's ability to get the signatures that were required. And then the first case that I found in time was back in August of 2020. That was Judge Wood. That was Orland Park, the village, and a couple of residents and a bar owner sought a TRO and a preliminary injunction, and those motions were denied as well. So again, I think that that's definitely the trend in all of the cases. Efforts to enjoin these policies, from stay at home to limits on gatherings to vax mandates, have all been upheld, or at least motions to enjoin enforcement of those policies has been denied.
So Brenda, I did have 2 cases regarding the vaccine mandate as it involved 2 federal contractors. My cases, however, basically dovetailed with Judge Kennelly's because it was the same union. So once Judge Kennelly issued his opinion in his case, in my particular case, that particular issue was mooted. So the motion for preliminary injunction that was at that time pending before me no longer went forward, in light of the fact that in my case was Amtrak, and Amtrak suspended that vaccine mandate. So it never went any further than that for the moment. So I have not had to weigh in on the issue myself, but as Judge Alonso has pointed out, certainly the trend in the Northern District, and I think it might in part emanate from the Seventh Circuit decision in Klassen as well, has been to deny these motions.
I think lawyers often wonder, especially when there's such a common topic facing a court with many judges, whether the judges are discussing these things among themselves. I don't know whether protocol prohibits you from addressing any of that, but is there anything you can say about whether there are internal discussions? We've talked about consensus, but maybe something short of consensus, at least conversation among yourselves on these topics.
I would say there's a lot of
Tone of silence. Is there like a tone of silence here that we can?
I would say there's a lot of respect for individuals making their own decisions, but there's also a lot of collegiality for talking through difficult issues. And so there's never a meeting where people say, okay, let's get together and talk about the vax issue, or let's get together and talk about this criminal statute that's new, you know, how are we going to decide on it, or anything even remotely like that. And of course, there's different fact patterns, you know, depending on what the issue is. But there certainly is, I mean, there are judges I call all the time and say, oh my gosh, what do you think about this? You know, I have this in front of me. I mean, it might be something as common as Title VII that, you know, we've all seen a million times, not something as novel or vaccine mandates. But here's my fact pattern, what do you think? And we all talk to each other and are sounding boards, because we really don't have it, just like you go down the hall to your law partner and talk to your law partner about how, you know, how what do you think about this? How would you present this? And there certainly is some of that camaraderie in the bench, but there's a lot of respect for, well, that sounds right. Yeah, Mary, that sounds, I mean, I hope that somebody would say, well, Mary, you sound like you're losing your mind right now, so you better rethink that one. But there's nobody ever saying, you know, no, that's dead wrong. But there's a lot of respect for your individual thoughts, but there's camaraderie in terms of thinking through complicated issues. I just want to say about the COVID thing, I didn't follow what was happening in the Supreme Court earlier this week, and I know the trend that we have because I have been following that, but the press out of there sounded, and I didn't listen to the argument, I'm sure it's available, but the press out of there sounded like that court is going to be rather hostile to a mandate. So that might shake up whatever we have going, depending on, and I don't think that was there on a TRO, so that's a different animal, but stay tuned.
Yes, and that was discussed in quite detail in our COVID session yesterday.
Okay.
But I think that you're right. Let me ask Judge Alonso and Judge Valderrama, since you both served on the state court bench before becoming federal judges, how has I mean, obviously now you're dealing with federal questions that didn't fall within your jurisdiction as state court judges, but are there any other ways in which your experience on the bench so far has differed from the state court bench?
I can go first, Jorge, if you don't mind. One of the things that I noticed very early on, and I came in the midst of the pandemic, so it's still the case, but one of the things that I did frequently in state court, sitting in the Chancery Division, was hold in-person contested hearings. And that was something that I will be honest, I enjoyed. I typically enjoyed the give and take with the lawyers in person, arguing a respective motion. That is something that obviously hasn't happened, and certainly not to the same extent, in large part because of the COVID management systems in place. But also, I think my sense has been that in federal court, generally speaking, I'm not saying, you know, specifically, but generally speaking, there's just less oral argument on motions, as some judges just don't find them to be as helpful. And I will admit, since coming over, I've had less oral arguments on contested motions as well. So that's certainly been one of the differences that I have seen. And coming out of the pandemic, I don't know that I will go back to the same volume of hearings, contested cases I did in state court, but I think at some level I probably will have and invite attorneys for oral arguments on, particularly on cases of first impression or novel issues that I'm looking to really engage the parties based upon my reading of the briefs. And by way of example, I had such a discussion within the last week where I had the parties come in for an oral argument on an issue of what I think might be first impression. So that's one of the differences that I have noticed.
Judge Alonso, have you experienced any differences? You've been on the federal bench a little longer, and you were, I think, in criminal. So how's it been different for you?
Well, it really is tied to the issue of what you used to do. Of course, in state court, we were specialists. So we did a particular type of case. Now we're generalists, so we deal with everything. So in my case, it really comes down to the fact that I was involved in criminal cases exclusively. So I think it translates here. If I was only doing criminal cases here, then there'd be a lot of similarities. But by its nature, a lot of what happens in the criminal context happens here on the bench. So my job used to be based on sitting on the bench and ruling and making decisions all day, immediate decisions, as opposed to my job now. So probably 75% of my cases numerically are civil cases now. The criminal cases probably take half of my time. But to the extent that we're talking about the civil cases and practice from a civil standpoint, it is very different. So most of what I do in those cases, I don't do on the bench. Most of what I do in those cases happens back in chambers. That's where the magic happens. Reading, writing, collaborating with clerks. Even in the criminal context, we spend a lot of our time preparing for sentencing hearings, preparing for change of plea hearings, et cetera. And of course, over the last 22 months, much of what we are supposed to be doing has gone away for the most part. I was supposed to be in the middle of a jury trial now and starting another one in a week, and they've both gone away because of COVID. We were finally ready to go, and we just couldn't do it. So very different. Also in state court, at least again, based on what I was doing, it was me. It wasn't a team, and I was used to and came up that way, relying, not collaborating as much, just sort of you without clerks, et cetera. So that part of it wasn't there. So very different from what I used to do in a lot of ways.
So I want to shift to talking about some substantive legal issues for a bit. Our last panel, and hopefully you in the audience were able to listen to that one. It was really excellent. That last panel discussed changing legal standards in discrimination cases. And one of the topics they discussed was the big change in the Seventh Circuit's decision in Ortiz, the 2016 Seventh Circuit decision that rejected the direct and indirect framework in analyzing discrimination cases. And there was discussion, as we've all had over these last few years, about whether Ortiz has made McDonnell Douglas obsolete. What is the viability of McDonnell Douglas after Ortiz? So I'm wondering, from the judicial perspective, how you are seeing lawyers handling the interplay between those two standards since Ortiz, and what is your own view about the continued viability of the McDonnell Douglas burden shifting framework after Ortiz?
I am seeing what I think is belts and suspenders. So I think lawyers are concerned about not covering the waterfront, which I understand, and they are doing both an Ortiz analysis and a McDonnell Douglas. Often they do the McDonnell Douglas analysis first and a bit more thoroughly, And then at the end, they say, okay, well, in case you want to hear about Ortiz, here's my Ortiz. Here's a couple of paragraphs on Ortiz. And the plaintiff, that's from the defense, of course, in a motion for summary judgment, and then the plaintiff responds in kind or not, depending on how that looks from the plaintiff's perspective. And then I feel compelled to issue an opinion that addresses all of that because it's all been presented to me. And I think that what the Seventh Circuit has said is Ortiz is the law, and we can operate under Ortiz. And I personally find that a more friendly, a more user-friendly standard. It's easier to comprehend, I think. It's easier to explain to real people, meaning non-lawyers, certainly non-judges, meaning people who are living with these decisions. So I prefer it. And just for me personally, I would rather not have to go through both analyses because I don't think it's necessary, but I don't want to disrespect the work that the lawyers have put into it. So I do tend to, maybe once or twice I haven't done this, but I tend to do both analyses if they're both presented in the briefs. But I would like to not do that. And I don't think it's necessary. I think the Seventh Circuit has been clear since, I think it was Judge Wood wrote Ortiz. And I think the Seventh Circuit has been clear since she did that Ortiz is the law. And when are we going to shake out from under this McDonnell Douglas? We've given people a couple of years now to shift. Let's shift. Let's move over. But I understand change is hard. And McDonnell Douglas was around for a long time. And so it's hard to shift, but I think it's time. I'm going to start dropping footnotes.
I think
the rest of you, do you feel that McDonnell Douglas has had its day and that we should only be talking in our briefs about Ortiz?
I know that I can't say mosaic anymore.
But you can say totality of the circumstances.
I agree with Judge Rowland, and in a sense, it's frustrating the intent, right, of Ortiz. They're trying to simplify and refuse to let it be simple.
Yeah.
I understand, and of course, they couldn't overrule McDonnell Douglas if they wanted to.
Right.
But I think, yeah, it's frustrating. We see what they tried to do, and the way it's playing out, it hasn't become simpler. It hasn't become simpler, but I think we'll get there. But I'm seeing the same thing as Dr. Rowe.
I would agree.
And I would say I've had this issue come up in the discovery context where parties argued that you're talking about McDonnell Douglas, but we're now living in an Ortiz world, so you can't get this discovery. And the Seventh Circuit is made clear that McDonnell Douglas still, it hasn't been abolished. It's still out there. And I think from a practitioner standpoint, perhaps it may be a little bit more tangible to some of the lawyers on the plaintiff side, what you need to do in order to create an issue of fact using that framework. And so that could be a reason you see some folks still sticking with that. Then the Ortiz gestalt, where everything's out there and it's kind of hard to tell what's enough, what's not enough. So I think you're likely to continue to see people using that format where it fits their facts from the plaintiff standpoint anyway. And I guess I don't see anything wrong with it. It may complicate matters, but if that's the best way to present your case and it's still permissible, why not?
Well, it is a Supreme Court law, but I was on a national call. I can't remember what it was about, but somebody from another circuit was saying, oh, we wish we could get Ortiz, something like that in our circuit. And I was like, I mean, you do, but you don't understand. Your briefs are just 8 pages longer because that you get the McDonnell Douglas analysis and then you get the Ortiz analysis. And that judge, I can't remember where they were from, was like, oh yeah, I hadn't thought of that. And I said, oh yeah, that's what comes. I mean, you don't be careful what you wish for.
Yeah. Yeah, the last panel actually, and it'll be in your materials, folks, talks about which circuits actually have gone the Ortiz route. It's not all of them, but it
Yeah.
is a couple. Obviously, the whole analysis comes up in the summary judgment context, but I want to touch on something Judge Cummings said, which is whether, before we get to summary judgment, in the discovery context, which I'm, as the magistrate judge, Judge Cummings, you probably are seeing more directly than the rest of you, although Judge Rowland, in your time as a magistrate judge, maybe you as well, whether Ortiz is changing the way you're handling discovery motions. Is it tending to make you allow broader discovery, narrower discovery, any impact at all?
I think it does provide for a little broader framework because of the considerations laid out in Ortiz. People can cite to that and say, because this consideration is here, I'll need this material, that material, and I'll still need these things for McDonnell Douglas. So I think it has the effect of potentially broadening the scope of what people are seeking. And it gives, and again, this from the plaintiff's perspective, it gives them a hook to base their demands or requests for discovery on, and a broader hook than they had before.
Judge Rowland, you were still a magistrate judge when Ortiz was decided. Did you notice any changes?
I didn't, although it was new. It was so new then. I mean, people really weren't adjusting to it, even in the summary judgment context, let alone in the discovery context. So I haven't, and I do a lot of discovery myself, but I haven't seen it impact the discovery requests. I don't know if you agree with this, Judge Cummings, but I think a lot of the discovery is still being driven by the McDonnell Douglas.
Yes, I think it is, but to the extent you want something outside of that framework, Ortiz gives you a hook to say, hey, this is discoverable too, because it says this is a consideration under Ortiz, and so you'll see that.
Totality, that's a big word, totality.
Right.
Total.
So summary judgment is where so many of us who practice employment discrimination law in the federal courts spend our time. And it's no secret that the federal judiciary is just inundated with those kinds of motions. And frankly, many that are meritless. And I say that both as a former defense lawyer and a current plaintiff's lawyer. But summary judgment motions I hear over and over again from the judges are so time consuming for judges to consider, so many pages to wade through, and yet they seem to be filed in almost every employment case. So I wonder, what are your thoughts on how the judiciary can manage the summary judgment process in a way that perhaps forces the parties to be more thoughtful about when to file them or whether to file them? Do you have any techniques that you use? I've heard, for example, judges talk about having, letters submitted in advance, or getting a second opinion from other judges, or having pre-summary judgment conferences. What are your thoughts on how we can sort of limit this fire hose of motion practice?
I really love Judge Durkin's practice. I don't know if he's kept it up during COVID, but I do like his practice of having the lawyers in before filing for summary judgment and talking through how they're going to approach summary judgment. So what are the claims on summary judgment, and is it really true that they believe that there's not material facts in dispute? And I've never been to one of his conferences. It's on my list of things to do. I understand that sometimes people decide not to file them. Sometimes it just narrows the number of claims they're going to bring on summary judgment. I mean, it has different impacts. Sometimes it might lead to discovery or settlement discussions. It's my intent to do that. When you first get on the district court bench, you kind of drown for a year or two. And so I'm just finishing my drowning. And I intend to, when I get above water, to start doing that. But that does take being caught up with everything that you have and then being on top of stuff as it's, before it gets filed and saying, hey, before you file that, come in and let's talk. But I do really like that because I think I never was a defense attorney, but I suspect there's some pressure to file motions. I don't think people are doing it for the fun of it. I think they're doing it in good faith. I don't know, but I think there might be some benefit to airing it and just sitting down and talking about it before you just pull that trigger. And that's one way that I think would be helpful. And I think Judge Durkin has felt very good about his process and has felt that it's been worth his time and has been successful.
Any other techniques that any of you are using or that sound intriguing to you to use?
Well, this is kind of indirect to the question, but it could short circuit a lot of summary judgment motions, which is in the initial status reports, having the parties indicate whether there's any interest or any settlement discussions. And so that if they've had some discussions or they're interested in a conference, you could kind of get them down that path before they expend a lot of time and energy litigating the case and on discovery and getting to these motions for summary judgment so that you exhaust your settlement possibilities before you get to summary judgment when that's possible. And many of the cases that I've handled, most of them, in fact, have come before a summary judgment motion has been filed and decided and lost, I guess, by whoever filed it. I usually get them before then, and that's really the best time in many senses of trying to settle a case before everyone's fees ratchet up and you put all this time and energy into it. Exhaust your possibilities of settlement, and that will cut down the number of summary judgment motions that are ultimately filed.
Well, to Mary's
I
point,
can't tell you how happy I am to hear that approach. I think that, and we're going to talk about settlement in a minute. I want to spend a couple more minutes on summary judgment, but I do want to talk more about settlement. But I think that the parties would all be well served by spending some time exploring settlement before everybody goes off to the very expensive races of summary judgment. I'm sorry, Judge Valderrama, were you going to say something?
I was just going to say very briefly that I am in that posture that Mary Rowland just discussed about drowning in the motions that are before the court. So I, unlike Judge Rowland, have not yet surfaced so that I can see the light of how I want to manage these motions in a better way. But I can say that, and I hope I'm not giving the wrong impression, but I don't necessarily take the view that all motions for summary judgment are problematic or a waste of time. Where I find them to be a waste of time is where they're just not well served, where the party moving more or less really knows that there is a genuine issue of fact and nevertheless files the motion. I like motions for summary judgment that narrow the issues. I find that to be helpful because the case is going to go on to trial, and my hope is that through that motion process, a couple of things happen. One, we've narrowed the scope of what the trial would be, and two, maybe at that point in time, it would open up the possibility for settlement once again, because you have now narrowed down what the available counts or remedies are available for the plaintiff. So I don't necessarily have a problem with motions. My issue is with motions that are not well taken.
So let's assume you've now got a motion in front of you. What advice can you give to lawyers about the best practices you'd like to see in a summary judgment motion? Not that it should be merit-based, let's assume that, but just in terms of how the motion should be approached to make it easiest for you as judges to consider.
I think one of the first things that I would be hopeful that the parties would do is, and it sounds obvious, is following local rule 56.1. Many of the cases that I have pending motions for summary judgment on are really, the record is long, it's lengthy. And I think to the extent that you can really focus your energy in your statement of facts, and you are citing the record through your 56.1 statement, that is very beneficial to the court in working its way through those statements of fact. So that would be the first thing that I would say.
Anyone else?
Short, shorter, and shortest. If you have 5 arguments and 3 of them are great and 2 of them are dumb, but you're just putting them in there because you feel like you should, take them out. I cannot tell you how much it denigrates your other arguments to throw in the kitchen sink, because we read so much paper and we do not want to read the junk that you threw in at 10:30 before you turned off your computer for the night. And I just really encourage you to tighten it up. And when you ask to file, instead of 15 pages, to file a 30-page brief, and 8 of those pages are arguments that are not worth making, I hear about it from my law clerks. And you hear about it from me, even though I don't say it out loud. So it's just, it's why? So I would just really focus on your great arguments, because you have some, and you really knock them down when you put in the ones that aren't really worth making. And I don't know if you're doing that because you don't want to waive something. I understand that. And maybe you put it in a footnote and say, we don't want to waive this, here it is, or something. But we all would appreciate it. We all would appreciate it.
Following up on Mary's
You're asking lawyers to overcome their natural impulses to be over-prepared and, you know, over-detailed. So we have to fight against our worst instincts.
I understand. I was you. I understand.
I agree, and it's not just I agree, and it's not just a very nice thing to do, but it also is effective, right? I mean, we're talking about your credibility. If you're going to lose 8 pages where you don't believe what you're writing, it's going to affect your credibility when we're reading the other 22 pages. So again, focus, make your strongest arguments, and of course, what Judge Valderrama said also, those rules are important, and we're going to strictly follow those rules. So you've got to abide by all of the local rules when it comes to these motions.
And a follow-up to that is, and I don't know about Mary and Jorge, Judge Alonso and Judge Rowland, but we often get motions for leave to file a brief in excess, and that's almost has become part of the norm. It's not the exception to the rule. It seems to be becoming the rule, and it ties in nicely with what both of them have just said, which is, why are you asking for additional pages if you don't really need the additional pages? Is it a reflexive action that you're just asking, and then you're going to just fill those pages with non sequitur, irrelevant arguments? Or is it really needed to make your point? And I think you should think about that before you even file the motion for leave, which should inform your actual motion for summary judgment.
You know, it was Mark Twain. You know, it was Mark Twain who said, "I'm sorry for sending such a long letter. I did not have time to send a shorter one."
One of my colleagues used to say his approach to brief writing was the KISS method: keep it simple, stupid.
I like that. I like that.
So, all right, let's talk about settlement, which we've alluded to. And Judge Cummings, you probably deal with settlement conferences more than your colleagues. I know Judge Rowland certainly did as a magistrate judge. What is your view? And Judge Cummings, you touched on this a little, but I'd like maybe both of you to comment on this. What is your view or your practice of how active the court should be in early resolution? And how do you think judges can be most helpful in the settlement process?
Well, I think encouraging the parties to engage. Sometimes what you'll see in initial status report is that plaintiff has made a settlement demand, but there's no response that's been made. Or sometimes a plaintiff hasn't made a settlement demand, which seems odd to me, but you see that sometimes too. And what I would do is order the plaintiff to make a settlement demand and a response from the defendant, and then have the parties inform me whether they're mutually interested in a settlement conference at that point. So at least they know where their respective positions are, and then if they're interested, then they can come and I could try to get them on that track as quickly as I can. Because one thing that really complicates matters in employment cases is the attorney's fee issue on the plaintiff side. These are fee shifting cases, and so the more you get into the litigation, oftentimes the plaintiff's attorney's fees can dwarf the recovery for the plaintiff, even if the plaintiff wins big. It's a lot easier to settle the case if you come in early before a lot of time has been put in by the plaintiff, and also on the defense side, because sometimes the defendant will look at it and say, well, look, I've got the budget like this for the case, and if I'm spending this much on defending it, that's less available for settlement. Or they get more entrenched in defending the case. It's always best to encourage them to think about it early, but you cannot force parties to settle a case, and you cannot force them to ask for a settlement conference. They have to see that it is in their best interest to do so. So that's the number one thing, but you want to have them have that engagement early rather than later in the process, especially in employment cases.
Judge Rowland, when you were doing more of these settlement conferences, what was your approach to getting involved and playing an active role in settlement?
Well, I think there's a lot of benefit to letting the parties, you know, a lot of times it's the plaintiff, but sometimes it's the defendant too. It depends what the entity is that's being sued. I don't know if you agree with that, Judge Cummings, but you know, if it's a smaller owner kind of thing in terms of a defendant. But I think there's a lot of benefit to people being able to come in and talk through what happened and have their, if you will, their day in court, their day in front of the judge. So I felt like it was offering, that part of my job was to offer people a platform, a venue that they could talk about what happened. And that sometimes, I mean, I sound like I'm trying to be a therapist here, but it sometimes gave them room then to move on the money because they had the space to vent, and not just to their lawyer, who they'd probably been venting to for months, years, but you know, to a neutral person. And it's sometimes it helped to kind of get the lawyer out of the way. I mean, with all due respect, but to, you know, to let the person talk to somebody who can really say to them, that's terrible, it's terrible what happened to you, but here's some real problems. You know, here's some legal hurdles that you're going to run into. And sometimes I think lawyers are really good at that. Sometimes it's a really difficult thing for a lawyer to do, or it's a really difficult thing for a client to hear. And I had plaintiff's lawyers sometimes take me out in the hall and say, I need your help. I need your help with this client. You know, fair enough. And I was a public defender, so I get it. You know, it's hard to talk to people about kind of the reality that they're facing in the law sometimes. So I think there's a lot of benefit to going to a settlement conference. And sometimes the defendant needs to hear that too. I mean, the law is what the law is, but I think judges, magistrate judges can really deliver that message in a way that, you know, lawyers can't always or don't always to their clients. So I think settlement conferences are really, really great. I loved doing them. I miss doing them. I'm lousy at them now. I mean, I don't know if I was any good at them before, but I cannot settle a damn thing now. I've had like 5 since I became a district judge. What?
Why do you think that is? Has there been a shift, or you're saying you're just not handling that many?
I think I've only done 5 or so, or 6 as a district court judge, and partly they're all remote, so I can't get that going. I don't have any mojo with that, but also I think I'm very timid because I'm going to be trying the case. So I'm much more tiptoeing around. And when I was a magistrate judge, I would be like, you know, that the judge is never going to allow that. Are you crazy, Judge so-and-so? Oh my God, she's going to have your head if you argue that. You know, I was much more blunt with people. And now I'm more like, oh, well, we'll have to see how the jury feels about that. I'm much more restrained. So I need to find a different way.
Well, and I think Judge Rowland is absolutely right that what people need to hear, there is oftentimes a disconnect between a concept of what is fair and what path the law takes you to with the situation that you're in. that exists not only for the plaintiffs, but also for a company or a defendant.
Yeah.
They may feel that they did everything right and still they have this lawsuit and they don't understand why it's not just going to go away, or why it might go in front of a jury, or why they might actually lose, even though they believe that they've done everything right. And it's important to listen to each side's presentation or story and then introduce to them what they're up against, whether it's the principle of law or other realities nowadays. I mean, with COVID, it's the delay. That's one thing I always make clear to the parties, is that if you think this is going to trial, or if your alternative, what's your alternative to settling? It's, well, I'm going to go to trial. Well, if you want to go to trial, it might not be for another year, especially if you haven't completed discovery, but even if you have. And that makes a difference to people, but they need to hear that. And it has changed. I think it has changed the dynamic in some of these conferences, because you could resolve it today or wait a year or a year and a half to try to go in front of a jury for an uncertain result. You know, and it makes a difference for people to hear these things.
I had an interesting experience in a settlement conference recently with one of your colleagues, where they brought in a new judge to sit in and observe. It was a virtual, and I didn't know if that was a court-wide practice or just this particular judge's practice, but I thought it was really excellent. And then I wound up having that magistrate judge in a later conference, and I think she really, benefited from having sat in. Are you seeing that? Is that a practice that is sort of just on an individual basis?
Well, it was done for me, and it was live with Judge Shanker, and I really appreciated him doing that. I mean, you don't necessarily come to this position with a fully skilled toolbox of mediation tactics and strategies, and so to see someone actually do it, I think that's a great thing that we do for each other when someone new comes. And as you mentioned, I think it's beneficial to the litigants and the attorneys as well to have someone who has a little experience before they get to you.
Mm-hmm. So we only have a couple of minutes left, and I want, especially for the benefit of younger lawyers, or I should say newer practitioners, what are some of the biggest mistakes that you see on both sides of the bar and employment cases? And conversely, what have you observed to be effective advocacy tools on both sides? Like, what are your pet peeves? The things you really, I mean, we've heard the don't ask for too many pages, don't throw in arguments that, just hit me with your best shot. Anything else?
I would add very briefly that I am not a big proponent or believer in arguments and footnotes. I find that distracting, and I don't particularly like substantive arguments and footnotes. So if you're writing a motion, so for summary judgment, from my perspective, it should be worthy of argument in the body of the motion and not relegated to a footnote. So I really don't care for substantive arguments in footnotes. Another quick point would be motions to strike affidavits in motions for summary judgment. I deal with those relatively often and don't find those particularly helpful either. So those are a couple of things that I would say to keep an eye out for.
Let me just in case we get cut off in the 1 minute we have left, the CLE code for our program is 221101. Again, 221101, and you can download the materials from the program. In the minute we have left, anyone else, pet peeves, things you like to see, things you don't?
I want to say something positive. I really want to encourage the more seasoned lawyers to let the younger lawyers get to the podium. I had a trial in September. I had the two senior lawyers. They did every witness. They each had an army of lawyers with them. I mean, army. Finally, the young woman at the table got to stand up and do a witness, and she did a great job. And I took her out in the hall later and told her what a great job she did. Please let these lawyers get to the podium. You guys don't try enough cases. They need to sharpen their elbows. They need experience. Get them to the podium. They're smarter than you. They're smarter than us. We could not get into law school nowadays, okay? These young people, they're smarter than us. They're more prepared. They know the record better than the older folks. Let them get on their feet, please. All the judges are patient about that. We want to see them. We want to hear from them.
Well, we've hit the 2 o'clock mark. I don't know if we're going to get cut off. So in case we do, I want to give a big thank you to all of our judges for your really insightful comments and all of the time that you've given to us. Thank you very much to our audience. Please go download the materials from the program. Please complete your CLE forms, and we would really appreciate if you would complete the evaluation forms. Your feedback is really valuable to us. So thank you to everyone, and have a great day.
Thank
Hope to
you.
see you at our next
Bye.
program.
Thank you.